Welcome to Immigration Answers with Seth.
Welcome to Immigration Answers with Seth, featuring immigration attorney Seth D. Stringer, founder of the Stringer Law Firm in Birmingham, Alabama. Seth helps immigrants in Birmingham, across Alabama, and beyond find safety and stability through VAWA petitions, U visas, family-based immigration, asylum, and naturalization. I'm Leann Lyon, and today we are talking about two things that can quietly derail an immigration case: not providing the information your attorney needs and waiting too long to file. Hello, Seth.
Good to be here.
Seth, when you're starting a new case, what kinds of information do you usually need up front, and why does that information matter so much for somebody's immigration timeline?
First of all, I would need to know what status they have inside the United States. Are they here on a visa? Are they here without permission? How they came into the country, whether they came into the country legally and overstayed, or whether they are still in status. Knowing that information, I can better determine if there's any other petitions or waivers that may be needed in order to get this client in a right status.
Many people hesitate to share details because they feel embarrassed or even afraid. How do you help someone understand that withholding information can unintentionally make their situation harder?
Generally, I first tell them that there's nothing that they can tell me that I haven't heard before. That usually puts them at ease at least a little bit to tell me what's going on. Yes, some of this stuff may be embarrassing. It could be sexual, but I would need to know, so I would better be able to ask more questions, more probing questions to get more information from them. If you don't give me information, if you don't give me the whole truth, if you don't give me details, then I cannot put forth a good petition or case for you. Therefore, I have to ask my clients multiple times sometimes. I need more details. I need more details. You've got to give me more details. What happened here? What happened there? If you don't tell me, then I'm not going to be able to help you. It's not going to be as believable unless you do give me this information.
When someone leaves out key facts, what kind of issues can appear later in the process they maybe didn't expect?
Probably credibility is going to be the biggest obstacle that they would have to overcome. If you don't tell the immigration, if you don't tell me the correct information, all the information that we ask for, then your credibility is going to be harmed and your story may not be believable. And if your story is not believable, then you will not be able to get the relief that you are seeking.
Without identifying anyone, can you describe a moment when a case changed direction, good or bad, based on whether information was shared in time?
I can tell you an example of a guy who came to me. We applied for a VAWA for him. He was involved in sort of business. It's not exactly illegal on the surface, but however, he did do some stuff that was a bit dodgy, I will say, and that really took his case off the rails. And we are actually still working on his case even 4 or 5 years after we started his case. If I had known this before, I could have told him, listen, you need to stop this. You need to go this other direction. However, whether he didn't want to tell me because he was embarrassed, whether he didn't want to tell me because he wanted to lie, whether he did not want to tell me because he didn't make it matter, is neither here nor there at this point in time. Now we are reeling from the consequences of him not telling me what exactly he was doing in his business. Again, what he was doing was not on its surface, did not look or seem important, but if you dug a little bit, then you could find out that it was detrimental to his case.
Immigration forms and evidence requests can really be overwhelming. What are some examples of small details that end up being more important than people realize?
One of the things I can think about are dates. If you say that you have lived with this person who you are basing your petition on a certain period of time, and that's not the case, then we do have a problem. Again, that brings into the question of credibility.
What are some of the hidden consequences people face when they wait too long to start an immigration case or respond to something from USCIS?
First of all, for the VAWA cases, it's important to start the case, to file everything, have it received by USCIS, not just mailed off to USCIS, but received by USCIS and accepted for processing by USCIS within 2 years of a divorce. Now, you can still file the VAWA while you are still married to the person you are basing your VAWA on. However, if you do get divorced, that puts you even in more of a crunch to get the paperwork done and filed and received by USCIS. If you do not file it within the 2-year period, then you are not eligible for the VAWA. Now, there are 3 types of VAWA cases. There are VAWA cases involving an abusive spouse, an abusive child, or an abusive parent who is a U.S. citizen or lawful permanent resident. So obviously, if the abuser is a child or a parent, then the timelines are not as strict as with a spouse. Again, you can file the petition as a spouse of an as an abusive U.S. citizen while you're still married, but once you're divorced, you are put on a strict timeline. If you don't get that filed, then you are barred.
Processing times are already slow. How can delays on the applicant side add months or even years to the overall process?
So what I do with clients is I give them a list of items that I need in order to complete the application and petitions. If you do not give me the information that I'm asking for, then chances are USCIS is going to issue what's called a request for evidence. And generally they give us 84 days to respond with the documentation that they are requesting. If we don't respond within that 84 days, then they could technically deny the case and you would be in perhaps even a worse situation than you would have been if you had filed nothing. Therefore, again, it's important for you to get me the information that I asked for from the beginning. If we don't provide enough evidence for USCIS and we do get a request for evidence, then again, give me the information as quickly as possible. Sometimes it's going to take a little bit of time for you to get me the information, whether that be court records, financial records, whether that be proof of status for your spouse, parent, or child. Again, you don't need to wait till the last minute. If you do wait till the last minute, then you probably will not be able to get me the information in a timely manner. And if I don't get that information timely, then I will not be able to present it to USCIS by the deadline.
Some people put things off because they think their situation might just work itself out. What are some examples of deadlines or opportunities that actually disappear when someone waits too long?
Well, again, if you don't respond to this RFE in a timely manner, that could mean that your application is denied. If your application is denied, then chances are, by the time it's denied, then the window of opportunity that you had to file your VAWA is closed. Another example is with the U visas. U visas are a bit different. They are a non-immigrant visa. However, there is a timeline. It may be vague, but there is a pseudo timeline for filing a U visa. By that I mean, in order to get a U visa, you had to get approval, so to speak, from the prosecutor or the law enforcement to apply for the visa. That means that I, as the attorney, would contact either the prosecutor or the law enforcement to see if they would be willing to sign off, so to speak, on filing this visa for my client. If they wait too long, they're not going to want to file charges against this person because they have other things to do. And besides that, you are just one person among many that are vying for their help. Another example is some of these crimes that qualify for a U visa designation are misdemeanors. That also means that if you do not press charges within 1 year of the commission of this crime, then the law enforcement cannot charge this person with a crime, and they will not obviously sign off on the U visa application for you. Therefore, especially for domestic violence, if you are the victim of a domestic violence, generally that's going to be a misdemeanor. I stress generally, because most of the cases that I've been in contact with involving domestic violence are assault 3 domestic violence, meaning that at least in the state of Alabama, that is a misdemeanor. If you don't press charges within 1 year, you cannot press charges after that. Other cases are felonies, and you have more than a year to press charges against this person. However, to show your legitimacy, to show your concern to getting a U visa, I would suggest you start this process as soon as you can. Obviously, especially with a misdemeanor, you cannot do it after a year.
For a person who feels intimidated by the process, what can help make the next steps feel less confusing or overwhelming?
The first thing you need to do is contact an attorney and set up an appointment to meet with him or her and discuss your options. Maybe the attorney doesn't think that your case qualifies for a U visa because you are the victim of something else that does not qualify as a crime under which you can apply for a U visa. Or perhaps the domestic violence that you have experienced is not as strong as it should be for a U visa. Now, keep in mind, it does not have to be for VAWA. It does not have to be physical violence. It could be intimidation. It could be emotional violence. It could be financial abuse. There are various ways you can be abused by a spouse and get a VAWA designation. But you will not know that unless you talk to an attorney. Therefore, if you are concerned that you may be in an abusive relationship, then contact an attorney, and he or she should be able to help you through that case and walk you through the process.
Well, that is it for today's episode of Immigration Answers with Seth. If you'd like to learn more about Seth and his work at the Stringer Law Firm, visit stringerimmigration.com. You'll find clear information about VAWA, U visas, family immigration, asylum, and other ways to protect your future in the United States. Thanks for listening, and remember to like, leave a review, and subscribe to the show so you catch every episode. Thank you, Seth.
Thanks for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.